Good afternoon. I'm going to call the judiciary meeting to order together, and we'll have members hopefully coming in. I want to thank everybody for being here. Just a few comments before we start our hearing on these bills. Bills regarding firearms tend to bring up kind of some intense responses from many folks, and so I want to thank you in response for being very respectful in your behavior as both if you're someone who's testifying or someone in the audience. I do want to remind you that there are no props that should be in the hearing room, and I won't be allowing any applause or audience commentary on testimony. I do want to make sure people understand how we've got these bills laid out for hearing because there are many more people signed in to testify than there's actually going to be time for testimony in these 2 hours. So the first bill, 2666, will have 25 minutes for the hearing. The next two bills, 1387 and 2422, will be heard together because I think people will want to comment on both of them, and we'll have 50 minutes to hear those bills. 2293 will have 25 minutes for that hearing, and the final bill, 2519, will have 15 minutes for that hearing. I'm going to keep the time very tight on this. You will, everybody, there will be panels of 3, and I'll let you know how long you have to testify. I think all the bills except for the combination of 1387 and 2422, that if you're commenting on those, you'll have 2 minutes for testimony. The others will be 1.5 minutes for everybody. Just so you know, the way the timers work is there's a green light, and then when you have 30 seconds left, there will be a yellow light, and then when your time is up, you'll get a red light, and you can finish your sentence that you're speaking, and you should be done then, or I'll ask you to wrap up. For those of you who are in overflow rooms, I know we have a couple of overflow rooms right now. The vice chair is going to be calling the panels that will testify. It will go pro and con with our panels. And so she'll talk about who's up to testify, who is on deck, and who is on hold. So that should give enough time if you're in an overflow room for you to get up into this room, and security will certainly let you in so that you can testify. And if it takes you a little extra time, don't worry, we'll work you in. You won't miss your chance, or I'll do my best to make sure you don't. My goal is to try and give as many people who are interested in these topics the opportunity to testify. And as I said, we'll alternate pro and con. I'm going to ask members to please only ask questions that help you understand the bill or the testimony, but we're here every day and we can ask staff questions anytime we want, and I prefer to err on the side of public testimony as much as we can. So with that, are there any questions from members? All right, then, we'll start off with House Bill 2666 and hear from Edie Adams. Staff.
Good afternoon. House Bill 2666 addresses local government authority to regulate firearms. Under the state constitution, local jurisdictions have the authority to adopt and enforce health, safety, and other laws unless in conflict with the general laws of the state or unless the state has preempted that authority. The law governing firearms does contain a state preemption provision that was originally enacted in 1983. That law provides that the state fully occupies and preempts the entire field of firearms regulation within the boundaries of the state, and local jurisdictions may enact those laws and ordinances relating to firearms that are specifically authorized by state law and consistent with state law. State law does authorize local jurisdictions to adopt regulations relating to firearms in certain limited areas, including certain locations where discharge of firearms may be prohibited, laws restricting possession of firearms in stadiums and convention centers operated by the jurisdiction, and laws regulating the areas in which firearms may be sold. House Bill 2666 repeals the state preemption statute and adds a new section to the firearms chapter indicating that nothing in the firearms law limits or modifies a local jurisdiction's authority to adopt firearms laws or ordinance that are in addition to or more restrictive than state law. It also repeals those areas where specific authority has been given to local jurisdictions. Be happy to answer any questions.
Are there questions for staff? Representative Macri. Representative Macri, I have this experience that maybe the theme of your bills this year is on preemption. Yeah. We saw you earlier on a preemption issue.
I was wondering if you were going to notice. For the record, I'm Nicole Macri, State Representative from the 43rd Legislative District in Seattle. And again, it's quite a great honor to be here in front of the Judiciary Committee. I bring to you this bill, HB 2666. I'm sure you all agree with me that we are very fortunate to live in such a beautiful and diverse state, and I expect that the testimony that you will hear today will help to exemplify that very diversity that we really value and honor here in Washington State. But for the last 30 years, local towns and cities and counties have been blocked from taking action to prevent gun violence in their own communities. We know that local leaders, including elected officials, police chiefs, and community leaders, know best what the dynamics of their communities are and how best to address those needs. And in some instances, including in the district that I represent, there have been efforts and conversations to limit gun access in certain public areas, like parks and libraries and places where kids learn and play. But the state statute, preemption statute, prevents that local action from being taken. This is contrary in value and practice to some of the laws that we have. For instance, in local communities, we do allow the option to prohibit guns in schools, but not in other places where we know kids go. So simply, as Edie said, this bill would eliminate that preemption and reintroduce the local control on firearms regulations that are tailored to the diversity of our communities, from our big cities like the one where I reside to our small towns where the needs could be quite diverse and different. I want to thank the testifiers who are going to come on both sides of the issue to share their experience and perspective on this, and I hope that you will give this bill serious consideration. Thank you.
Representative Rodney.
Thank you, Madam Chair. Thank you for bringing the bill forward. One of the aspects of preemption that is beneficial is that there's a uniform standard. How does your bill address the likely scenario, if it becomes law, where citizens will be in violation in one city and they'll travel either through work or whatever, along the I-5 corridor, they're in violation in one city, they're in compliance with another city, they're in violation. How does your bill deal with that situation?
So that is a situation that's not uncommon in lots of other areas. So I know, for instance, in my city, we just changed the speed limit. So on arterials, the speed limit moved from 30 miles an hour to 25, and in the side streets to 20 miles an hour. So that differs from cities around us. In my city as well, talking about prohibitions in public parks, in Seattle, you are prohibited from smoking cigarettes in public parks. That's not true in other areas and may not be appropriate in other areas that are not urban, more crowded areas like Seattle. So I think we are accustomed to having different ordinances across different areas of the state. So thank you.
Thank you.
Yeah.
With that, we'll open this up to public testimony.
Yes, thank you, Madam Chair. Our first panel will be Paula Barnes, Debbie McDonald, and then Mike Nelson. On deck, it will be Gray Wonderly, Ira Moser, and Brian Zielinski. On hold will be Chris Bandoli, Jessica Goldman, and Catherine Wilcock. Good afternoon to each of you here coming to share your testimony.
Welcome. Go ahead.
Good afternoon. My name is Paula Barnes. I live in Sequim in the 24th Legislative District. We've traveled from our rural community today to ask you to vote in favor of House Bill 2666, Restoration of Local Authority. There is strong and widespread support in our rural district for reasonable gun laws. But state law currently blocks local jurisdictions from establishing firearm regulations that are responsive to local needs and interests. Gun violence prevention should happen at every level of government. If residents of a city or county feel it's important to limit guns in certain public spaces, they should have the authority to do so. I'm a retired library director. I spent more than 3 decades working in public libraries where seniors, business people, parents, and kids gather on a daily basis to read, learn, and enrich their lives. If a local jurisdiction wants to establish a public safety law to keep guns out of their library, they should be able to do so. I've heard the argument that it would be confusing to gun owners to deal with differing regulations from one city to the next. But local governments can enact their own rules for traffic, for smoking, fireworks, and other matters. Guns shouldn't be any different. Please vote in favor of House Bill 2666. Thank you.
Thank you. Go ahead.
Good afternoon. My name is Debbie McDonald, and I live in the 46th District in Seattle. I am a proud retired teacher from Seattle Public Schools, an avid patron of our nationally recognized public library system, and an enthusiastic user of the Seattle parks. I have visited all 410 of them. In 2013, I was shocked to learn that guns were allowed in my city libraries. At that time, Grandmothers Against Gun Violence and Moms Demand Action staged a peaceful sit-in with children and stories at the Central Library to highlight the library board's inability to change that. Why couldn't they make the library gun-free? State law. Working in a public school where firearms are prohibited, I had assumed that other places in Seattle where children and families congregate, like parks and libraries, would have the same restrictions. I knew there were also a strict ban on guns in sports stadiums, but our libraries and parks, not so, and nothing that I can do about that. As a resident of Seattle, I feel I deserve an opportunity to lobby locally for gun-free zones. Gun violence prevention is so important in this day and age, and it's important that we deal with it both at the local level, the state level, and hopefully at the federal level. Restoration of local authority will allow us to work on it locally. If city leaders and residents like me believe it's important for safety to limit guns in certain public spaces, like my parks and libraries, we should have the authority to do that. Thank you very much.
Thank you. Go ahead.
Good afternoon. My name is Mike Nelson. I'm a council member for the city of Edmonds, a dad, and a gun owner. I strongly believe we should be doing more to prevent gun violence, and particularly in our city, I helped pass the second city in the state of Washington requiring the reporting of lost and stolen firearms, as well as resolutions supporting safe storage of firearms. Since the founding of our state, local governments have had broad powers to protect the health and safety of our residents. We determine how fast or how slow you drive on our streets, that you don't bring knives into our parks, or when you call for help, we ensure you will have police and firefighters there in your time of need. But 35 years ago, a state law was passed taking away local government's ability to properly protect our residents from gun violence. This law treats the needs of big cities and small rural towns like we're all the same when we know we're not. The question we need to be asking is whether this law has made our communities more safe. I'm here today to tell you it has not. Gun violence continues to invade every aspect of our lives, in our schools, in our streets, and in our homes. Our children, our babies, should be free to play in a park without being surrounded by those looking for a gunfight. If our city does not want firearms where kids play, we should be able to decide that. Please give us back our authority to prevent gun violence and allow local governments to build and improve the state gun laws that we have. Thank you.
Thank you. Questions for the panel? Thank you.
Once again, up next is Gray Wonderly, Ira Moser, and Brian Zielinski. On deck, Chris Bandoli, Jessica Goldman, and Catherine Wilcock. On hold, Sherry Erickson, Steve Erickson, and Mike Silvers.
Thank you. Go ahead. Whichever one of you wants to start is fine.
Okay. Thank you. My name is Gray Wonderly. I live in Marble Mount, Washington. Okay, the thing we're talking about here, and I've heard them say, well, we have the authority to change speed limits. We have the authority to regulate other things, but those other things are not guaranteed rights under the Constitution. They are privileges, but not guaranteed rights. Guaranteed rights means a person has the right to defend himself anywhere he is, in the country or in the state. So by doing something like this, you would be taking away that person's right to defend themselves wherever they are. The next point is that if you think carefully about it, and I mean think carefully about it, more crimes are committed with firearms in gun-free zones, nationwide and statewide. Everywhere we've had a mass shooting in this state, for the most part, it has been in a gun-free zone. If someone wants to come in, a criminal, crazy person, whatever, and start shooting the park up, no law you pass is going to stop him. But what might stop him is a good guy there with a gun to stop him from doing any serious damage, or at least limiting the damage he can do. Thank you.
Thank you. Go ahead.
Hi there. My name is Ira Moser. I'm from Snohomish, Washington. I appreciate the opportunity to speak today. I strongly oppose House Bill 2666, and you should too. It seeks to abolish Washington's decades-old state firearm preemption statute. The state preemption statute, which passed in 1983, helps keep firearm and ammunition laws consistent throughout Washington by establishing that the state legislature alone has full authority to regulate and create laws pertaining to firearms and ammunition. These statutes help to prevent a confusing patchwork of gun control laws, which make it difficult for gun owners to ensure that they are following the law. Further, our state and federal constitutionally protected rights to keep and bear arms are guaranteed to all citizens, regardless of where they reside. State preemption statutes help protect against the infringement of these rights of citizens who live in localities controlled by anti-gun elected officials. Thank you very much.
Thank you. Go ahead, sir.
Thank you. My name's Brian Zielinski. I live in the 45th. I'm represented by Mr. Goodman and Mr. Springer. One of the biggest problems that I see with HR 2666 is we've heard common sense. We've heard it's like a speeding ticket. It's like smoking outside. Well, if I get a speeding ticket, I might get a $50 ticket. If I smoke outside, I might get a $100 ticket. If I carry my gun in the wrong area, my kids might not get to see dad at home that night. And that's a bad thing, right? You're going to put a law in place where if I travel into another city, I travel into another area, I have the ability to really harm my family just by trying to defend myself, just by carrying my weapon in a legal fashion. I really think that you guys need to really look at your oath to the Constitution of the state of Washington and your oath to your constituents, and do not let emotion make your decision for you. Guide yourself by the Constitution of the state of state of Washington, and let that make your decision. I thank you for your time.
Thank you. Next panel.
Next panel, Chris Bandoli, Jessica Goldman, and Catherine Wilcock on deck, Sherry Erickson, Steve Erickson, and Mike Silvers on hold. And following that second panel, Marjorie Toman, Dylan O'Connor, and Mallory Toman, Dylan O'Connor, and Marjorie Whitmore.
Go ahead.
All right, thank you, Madam Chair and members of the committee. For the record, my name is Chris Bandoli, here on behalf of the Washington State Hospital Association in support of House Bill 2666. Some of you might be wondering why the Hospital Association is involved in this conversation. What we're not here to do is debate the larger question of firearms in society, though it's important to note that our members' emergency rooms and ICUs are all too often the end destination for the impacts of violence of all types in our communities. We're here because whatever their opinion of the larger role of firearms in society, the leadership of our hospitals all agree that a hospital is not an appropriate place for guns, and that every hospital should have the ability to adopt enforceable policies to restrict firearms on their premises. Our board even passed a unanimous motion to this effect at our December board meeting. Hospitals are places for healing, full of incredibly vulnerable patients, the incapacitated, the elderly, the mentally ill, and children. Hospitals are also the work sites of dedicated employees, doctors, nurses, providers, and support staff of all types focused on caring for patients. So again, why are we here on this particular piece of legislation? 42 of the 107 hospitals in Washington State are public hospital districts, meaning they are regulated in much the same way as the other local government entities covered by this statute. Because of state preemption, it is unclear under today's law whether a PhD could adopt an enforceable restriction on firearms in their communities if they so chose, or in their facilities, I should say, if they so chose. House Bill 2666 would remove that uncertainty and guarantee those hospital districts the ability, again, if they so chose in consultation with their publicly elected boards, to adopt policies limiting firearms in their facilities, or enforceable policies, I should say. We understand this is part of a much larger, incredibly passionate conversation, and we would like for this narrow part of it to be part of the conversation moving forward. Thank you.
Thank you. Go ahead.
Good afternoon, Madam Chair and the committee. My name is Jessica Goldman. I am a voter in the 32nd Legislative District. I'm a parent, I'm a constitutional lawyer, and I'm an organizer for the North Seattle Progressives. Local governments play a vital role in making public safety laws on mundane issues such as traffic and curfews and building codes and cigarette smoking, but also on areas that are protected by both our federal and state constitution. Local governments play a special role because they know their communities and their community needs. Gun violence prevention is a critical public safety issue. Today, not even at the end of January, we already in this country have had 10 school shootings, as compared with 0 that have happened in our neighbor Canada to the north. Local governments today are blocked from taking the basic steps they need to protect their communities. And gun violence prevention is at the top of the list of issues that they should be able to address. Our NRA friends here are wearing badges that say stand and fight. I urge a different approach. We are communities of laws, and we should be able to make those determinations in our communities. The notion that we are patchworking our state is no different than our state laws. Our folks travel up and down I-5 and other state corridors and highways and face different laws from state to state, and they need to comply with those states. We urge you, and I urge you, to please restore the vital authority of our towns and cities and permit them to govern on this critical issue. Thank you.
Thank you. Go ahead.
Hi, my name's Kathy Wilcock, and I'm a resident of Edmonds in the 32nd District, and appreciate the opportunity to come and testify on behalf of this bill today. Just on sort of a personal note, a couple of years ago, I think really sort of soon after Sandy Hook and the Marysville-Pilchuck incidents, a group of us in Edmonds, a core group of friends that I associate with, got together. We just sort of said enough is enough. We really want to do something. We want to figure out how to make Edmonds a safer place. We want to figure out what we can do at a local level and make progress in this area. We just felt that we really needed to do something. And unfortunately, very shortly into our research of what could be possible, we learned about the preemptive law, and just at that point just really felt powerless. We felt powerless as a group of friends. We felt powerless as a community. We just didn't know where to turn. So we're very thankful to having representation like Edmonds City Councilman Mike Nelson, who you heard from a little bit earlier, and has the focus and has the relationship, as many of the leaders on the local level have, directly with their citizens and with their community. And because of that, at the local level, we're able to reach out and participate and feel empowered to shape our communities, to protect our communities, to keep our families and our towns safe. I think that this proposed bill is one where it's not saying what is going to be ruled, it's giving that authority and that empowerment to the local groups, and gives an opportunity for us to try things at a local level that then can be potentially broadened at a broader state level. Thank you for your time.
Thank you. Thank you to the panel. Next panel.
Next panel, Sherry Erickson, Steve Erickson, and Mike Silvers. They will be followed by Mallory Tillman, Dylan O'Connor, and Marjorie Whitmore. And then the final panel for today on this bill will be Phil Watson, Ernest Rodriguez, and William Murphy. Good afternoon to each of you here.
Go ahead.
Thank you, members of the committee. My name is Mike Silvers. I strongly oppose any changes to state preemption. The reason is I was arrested 35 years ago stopping for gas in Chelan. I didn't know they had a law that said in the vicinity of a tavern. I stopped for gas. There was a tavern around the corner with no sign visible. I was arrested because I had a firearm in the vicinity. I spent thousands of dollars getting that cleared up. There is no reason of any kind to even tamper a little bit with state preemption. I did nothing wrong, but I got arrested because I stopped for gas. I'm sorry, but that's it. No.
Thank you. Go ahead.
Hi, my name is Stephen Erickson. I'm the 28th District. Thank you for the opportunity to share. First of all, on the bottom line for me on all of these issues is we are not going to stop somebody from being violent. If they're going to choose to be violent, they're going to be violent. There are mental health laws that can be enacted, but even then, it still is a matter of choice. I worked in the mental health field for, 20 years. I worked as a minister, trying to help people. But the bottom line, again, is this law doesn't make a whole lot of sense. The reason why the preemptive law was put in place in the first place makes sense to me. I have no desire to get arrested because I'm driving through an area and I have a concealed carry permit. I don't think that's just not great. I believe in the right for people to defend themselves. And imagine a park where there was nobody there with a gun. Somebody opens up because they're gun anyway, and somebody's there able to stop them. So I'm in favor of protecting people too. I care about people. Thank you.
Thank you. Go ahead.
My name is Sherry Erickson. I'm a resident of Pierce County and a responsible gun owner. As a woman, I have the right to protect myself and my family, not only in my home, but also in public places. Declaring a particular area as a gun-free zone doesn't keep guns out of that area. It keeps law-abiding firearm owners from being able to protect themselves and their family in those areas. I take my grandkids to parks and libraries in the city where we live and also in other places. And being able to conceal carry and protect, again, myself and my family is really important to me. Being able to level the fight in any sort of a situation where there's someone with ill intent towards anybody else in that area is really, really important. I do stand and fight, and what I stand and fight for is a woman's right to protect herself and her family. And so as a wife and a mom and a grandma, I thank you in advance for voting no on these bills, this one and the others as well, and protecting a woman's right. Thank you.
Thank you. Thank you to the panel. Next panel.
Next panel, which is the second to last panel, Mallory Tillman, Dylan O'Connor, and Marjorie Whitmore. And the final panel to follow that second to last one, Phil Watson, Ernest Rodriguez, and William Murphy. Good afternoon.
Good morning. My name is Dylan O'Connor. I'm a student at the University of Washington living in the 43rd Legislative District, and I'm a proud intern at the Alliance for Gun Responsibility. I'm here today to make the point that local government's duty is to represent and protect the needs of their citizens. And yet cities and towns under the current law are unable to make the best choices for their communities, especially when it comes to gun violence prevention. Gun violence prevention can and should take place at every level of government, and preventing local communities from enacting their own standards, it goes against their duties and places them in an awkward situation. City governments can make other public safety laws, traffic rules, city curfews, and building codes. For example, Seattle has a ban on smoking cigarettes in public parks. This is not a state law, and not every city carries the ban. But as a city, it makes sense for Seattle, so that's what they do. It's not unprecedented to have different local ordinances enforcing different rules across cities and towns. and people are currently navigating these differences between city and county laws with ease. Guns should not be any different. That's my short bit. Thank you very much.
Thank you very much.
Okay, next panel, Phil Watson, Ernest Rodriguez, and William Murphy. And then we have two other individuals who actually we will have join following them, Sharon Hinchcliffe and Boyd Nealand.
I'm William Murphy. I think there's a typo.
A lot to say. If you have some time, forgot to
Thank you, Madam Chair, members of the committee. My name is Phil Watson with the Firearms Policy Coalition, and I am in opposition to this bill, as well as my group and the members I represent. This will allow a confusing patchwork of laws that will surely ensnare thousands of unknowing citizens and legal residents from town to town, county to county, and a confusing array of laws that would change faster than the Western Washington weather. Moreover, the state of Washington's wise and reasonable preemption statutes ensure that law-abiding people and law enforcement officers alike can rely on a well-considered, consistent framework of laws. This law would allow local governments across the state to put good people at risk of accidental law violations and severely chill the exercise of fundamental individual rights under the Second Amendment and the Washington State Constitution. This bill has many flaws, but one clear intent: to undermine and chill the exercise of fundamental individual rights. If this measure were about marriage, bookstores, churches, cars, hospitals, voting, or abortion clinics, it would be dead on arrival. And so too should this bill be roundly and summarily rejected. For all the reasons I've stated above, we must oppose this bill and urge your no vote. Thank you.
Thank you. Go ahead.
Yeah, my name is Ernest Rodriguez, and I oppose House Bill 2666. And I'd like to start by saying that I am using no props tonight or today. I do not have a baby in my arms, and I am not wearing my uniform. I'd like to say, if you have not read this bill from front cover to back cover, and you support this bill, I ask you why. Why do you support something that you don't fully understand? Okay, I'm going to get to the meat and potatoes, because a lot of this has been general. House Bill 2666, page 4, section 3, subsection 6B. Of this subsection, a business selling firearms may not be treated more restrictively than other businesses located within the same zone. This sentence would be removed from state law, allowing municipalities, cities, and counties to impose more restrictive requirements on firearm businesses. This would open the door for more jurisdictions to close businesses such as selling firearms. Secondly, page 3, section 3, subsection 2A, such laws and ordinances shall not abridge the right of the individual guaranteed by Article 1, section 24 of the state constitution. This sentence would be removed from state law, opening a multitude of lawsuits against municipalities on the basis of unconstitutionalities. There are over 1,000 municipalities within our city, or our state. Seattle was in fact sued and lost over its gun-free policy in public places. And lastly, I want to say about page 4, section 3, subsection 4. Violations of local ordinances adopted under subsection 2 of this section must have the same penalty as provided by state law. This sentence would be removed from state law. With several hundred municipalities within our state, penalties could range between probation and a year or more for jail for the same violation. Thank you.
Thank you. Go ahead. Oh, hold on just a second. We just want to call up our last person just to make sure that they get a chance to get here if they're not here.
Yeah, Boyd Nealand.
So Boyd Nealand, if
You're
you're
on
here,
deck.
come and sit in the first row. Thank you. Go ahead.
Sharon Hinchcliffe, District 37, South Seattle. Member of Seattle-Tacoma Pink Pistols. Member of the Western Washington National African American Gun Association. Member of a Blue Line family heritage going back 100 years. I have had family and friends who have been murdered and who have died due to gun negligence. I am here today to speak against HB 2666 for the state preemption and the rest of these gun control measures. I stand against these racist, bigoted, homophobic, anti-civil rights gun control measures that do nothing to protect the individual citizens of Washington state, but intentionally violate the Constitution of the United States and the Constitution of Washington state. The duplicity that is being pimped as a feel-good so-called safety measures mean nothing when there is no constitutional right to be protected by the government or the police from being brutally raped, assaulted, or murdered by criminals or a madman. Decided in the 7th Court of Appeals, passage of such anti-civil rights bills to be voted on by the full House and the Senate is a public outing of each member of the Washington State Legislature as a homophobic, racist, sexist bigot, intent on destroying any ability of an individual's human right for self-defense. Thank you.
Thank you to the panel. And now I think the last person to testify is Boyd Nealand. Would you happen to be Boyd Nealand?
I do. Welcome,
Come on
sir.
up.
Thank you.
Thanks for hearing my testimony. My name's Boyd Nealand, and I'm the project director for the Citizens Committee for the Right to Keep and Bear Arms. In my spare time, I'm also the volunteer president of Washington Arms Collectors, and I've been a certified firearms instructor for 20 years. Since 1983, Washington State has reserved regulation of firearms to the state government, a practice that allows law-abiding gun owners to understand the law and not risk accidentally violating it as they simply go about their day-to-day activities. Without preemption, a daily drive from work to the store and back home could involve 3 different sets of laws, revised at unpredictable times by 3 different bodies, each enforced inside boundaries that aren't visible anywhere except on a political map. And let me just flesh that out a little, because this morning I found out that in the 2012 U.S. Census, we were told that Washington State had close to 2,000 local governments, including county, cities, and towns. In King, Pierce, and Snohomish counties, the most populous counties, there are anywhere from 86 to 157 units of local government within each county alone. So imagine the lines you cross in your daily life just going from legislative area to legislative area. Different areas where different laws could apply. Preemption is such an obviously good idea that since 1983, 41 states have followed our lead and enacted similar legislation. Now is not the time to go backwards. Safety concerns should be addressed with legislation that don't make exercise of our Article 1, Section 24 rights under the state constitution impossible. Please respect the logic of enforceable laws and oppose HB 2666.
Thank you. With that, we will close the hearing on House Bill 2666. We're going to open up the hearing and hear the staff report on 1387, and then the prime sponsor testimony, and then right after that, we'll hear the staff report on 2422 and the prime sponsor testimony, and then we'll go into public testimony on these.
For House Bill 1387, there is a proposed substitute bill in the EBB, and I will be speaking to that instead of the original bill. Proposed substitute House Bill 1387 establishes additional background check requirements with respect to assault weapons and large capacity magazines. Assault weapon under the proposed substitute is limited to semi-automatic rifles that have the capacity to accept a detachable magazine and that have one or more of certain listed features. The term doesn't include semi-automatic pistols and certain other firearms. Large capacity magazine is generally defined to mean an ammunition feeding device with a capacity to accept more than 10 rounds of ammunition. Under the proposed substitute, the sale or transfer of an assault weapon or large capacity magazine is subject to the same requirements that apply to the sale or transfer of a pistol. This includes a requirement for a state background check by local law enforcement in addition to the federal NICS background check. Also a requirement that the purchaser complete an application that contains specified information about the applicant and the assault weapon or large capacity magazine being purchased, and a requirement that the dealer maintain transfer records and transmit those records to the Department of Licensing. In addition, under the proposed substitute bill, a person who is under the age of 21 but at least 18 years of age may only possess an assault weapon or large capacity magazine on in the person's place of abode, fixed place of business, or on real property under that person's control unless certain other exemptions apply. The proposed substitute does not include any of the provisions in the original bill that required a license in order to possess, purchase, transfer, sale, manufacture, or import an assault weapon or large capacity magazine. Be happy to answer any questions.
Thank you for that report, Edie. Do we have any questions for Edie Adams about the bill? Okay, we welcome our chair, prime sponsor of the bill, Representative Jenkins.
Thank you. Thank you, Representative Kilduff, Vice Chair Kilduff. For the record, my name is Lori Jenkins. I represent the 27th Legislative District, most of the city of Tacoma, and the entire city of Ruston. Thank you to Edie Adams for her excellent a staff report on this. You will note that this bill is different than the bill that we heard last year, and it significantly narrows the bill this year, removing the provisions for requiring a license for assault weapons and large capacity magazines. So that's no longer in there. And then we've also tried to significantly narrow the definition of assault weapons. What I tried to do in the bill this year is to align the requirement for owning assault weapons with the requirements for owning a pistol in this state. Same background checks, requiring someone to be over the age of 21 in order to own them. And I want to just tell you why I'm focusing on this. It's because I think we've all been focused a bit on keeping dangerous weapons out of the hands of folks who are dangerous. And what we knew 25 and 30 and 40 years ago when we adopted legislation was very little about a young person's brain development. And we know a lot more now, and we know how hard it is for someone to control their impulses until they actually get well into their 20s. And so having access to a dangerous weapon like an assault style weapon for someone who's under 21 is just, they're dangerous people. It's just the brain is not developed well enough yet. And I think that we saw this a number of years ago in the shootings in Mukilteo, in which a young man killed 3 of his classmates and injured another. And when he was finally sentenced, I want to read his comments when he was finally sentenced to prison. He said, Alan Ivanov is his name. He said, "I will never speak to the public again. I forfeited that right. But I would like everyone to hear loud and clear that it was the ease of acquiring a gun that enabled me to act on my emotion. I don't mean to absolve myself of guilt or dodge responsibility, but I know for a fact that given the feverish state I was in, I never could have done this with my hands. I wish they never sold me a firearm, and I wish I was never legally allowed to buy one." This young man is the kind of young man that we are attempting to address, to make sure that we create more safety in our communities and try to make sure that folks who are maybe just not, ready to have a firearm do not have one, and that we have more safety. So with that, I would like to note I'm still open to dialogue on the definition of assault weapon. I've gotten some responses that say your definition is all wrong, but don't get any feedback from people about what the right definition would be. So I'm a little bit working in the dark on this and have sought out as many people as I can and would welcome other suggestions on that end.
Thank you. Any questions for the chair and sponsor of this legislation? Okay, with that, we're going to move to a briefing from staff on House Bill 2422, and then hear as well from the sponsor of that legislation, Representative Peterson. Edie?
House Bill 2422 addresses large capacity magazines, which has the same definition as under House Bill 1387. The bill makes it unlawful for a person to manufacture, import, purchase, possess, transfer, or sell a large capacity magazine except as specifically authorized, and a violation is a gross misdemeanor offense. The offense does not apply to possession of large capacity magazines that are legally possessed on the effective date of the act, or those that are inherited by a person who legally possess the large capacity magazine. Possession under these circumstances is subject to some conditions. The large capacity magazine may not be sold or transferred in Washington other than to a licensed dealer, a licensed gunsmith for service or repair, or to a law enforcement agency for purposes of relinquishment. It must be stored in secure gun storage, and it may be possessed only on the owner's property or while in use at a licensed firing range or in a lawful outdoor activity such as hunting, or while traveling to or from those locations. There are quite a number of other exemptions that are provided in the bill, and I've listed those in the bill analysis. That concludes my remarks. I'd be happy to answer your questions.
Are there questions for staff? Representative Peterson.
Thank you, Madam Chair, members of the committee. For the record, I'm Strom Peterson, representing the 21st District. And Madam Chair, you mentioned it, in the 21st District is the city of Mukilteo. And that's why I'm here today. The young man that you mentioned had 30 rounds in a gun that he purchased just the day before, a gun and a high-capacity magazine. And when I think about that, and I'm good friends with the assistant county prosecutor that had to show up that night, good friends with the mayor of Mukilteo who got a call that night. And I couldn't imagine, just as as a politician getting that call, but certainly couldn't imagine getting that call as a parent or as a friend, to see that kind of destruction. I grew up in a family in New Mexico that, we did a lot of outdoor activity. We hunted, we fished. And what really strikes me about these high-capacity magazines is this idea, and it mentions that here, but I don't know a hunter who hunts with a high-capacity magazine. Actually, in the state of Washington, with a shotgun, you can't have a shotgun with more than 3 shells, because that's sportsman. That's sportsmanship. So I do not understand the need for these high-capacity magazines, outside of, if perhaps, as the bill states, if you want to use it at a shooting range. But I think that this is an opportunity for this committee, and I appreciate the dialogue, and I really appreciate just having these hearings and making sure that we can talk about some of these issues openly and respectfully. But I think this is one of those issues that is very clear to me, that the need for a 30-round magazine, I simply don't understand it, and I think this is a common sense measure, and I look forward to working with everybody on this issue and other issues. And just one final point, I think somebody spoke earlier on one of the bills that X bill or this bill, and certainly this bill is not going to stop gun violence. None of these bills is going to stop gun violence. But if we can reduce the impacts of the violence that happens in our community, I think that's an obligation that we need to take on. So with that, again, Madam Chair, members of the committee, I really appreciate the time that you've given to this issue today and in previous days. And with that, I would gladly take any questions.
Thank you. Representative Klippert.
Thank you, Madam Chair. Representative Peterson, do you happen to recall how many rounds the gentleman fired in that Mukilteo case that you referred to?
I don't. I believe that in the process that he did not get off the entire 30 rounds, because I think the gun jammed on him because he had just purchased it the day before, so he didn't really know how to use it. But I do not know that number.
Yes, is trying to understand the relation. Thank you.
Thank you. Any other questions? Thank you, Representative Peterson.
Thank you.
With that, we're going to open up our testimony.
Yes, with that, would AAG Matt Thomas, Jim and Anne Marie Parsons, and Beth Ebel come forward? They'll be the first panel. They will be followed by Keely Hopkins, Jane Milhans, and Don Amen. And then on hold and following that second panel will be Raymond Miller, Zachary Elmore, and Beatrice Seward. Welcome.
Go ahead. Why don't you start off from the AG's office, since these are pieces of AG request legislation.
Thank you, Madam Chair, and thank you for sponsoring this legislation, and thank you, Representative Peterson, for sponsoring this legislation. I'm Matt Thomas. I'm an Assistant Attorney General here in Washington State. I'm also a veteran of Iraq and Afghanistan and spent several years as a legal advisor to U.S. Army Special Forces. In Washington, pistols require an additional background check, an enhanced background check. You have to be 21 years or older in order to purchase them, and you have up to a 10-day waiting period. Assault weapons, however, don't have such restrictions. An 18-year-old can walk into a sporting goods store and purchase a weapon and walk out without being subject to the enhanced background check. The Supreme Court, the U.S. Supreme Court in D.C. v. Heller, specified that, quote, weapons that are most useful to military service, M16s and the like, end quote, were exempt from many Second Amendment protections. It's important to note that when we're talking about these assault weapons, we're talking about these assault weapons not because they look scary, but because they are in fact combat weapons that are used by the military. The AR-15, which was adapted by the military as the M16 that was referred to in Heller, was specifically developed for the military to more than double the lethality of the individual soldier. Its design, its 30-round magazine, is designed to be lightweight and highly lethal. These weapons are also specifically marketed to civilians because of their tactical and combat usefulness. In fact, a survey of Cabela's says that 84% of the semi-automatic centerfire rifles are marketed as, quote, tactical. That's actually a radial button that you press. You can also purchase an FN SCAR, Bushmaster Advanced Combat Rifle, or an M249 at a store or online, and these weapons were all designed specifically for military use, and they're marketed that way. In fact, when I was at a special operations in Afghanistan, we used those weapons to hunt and kill the enemy. National crime statistics compared to the low density of assault weapons, which is 8% of the firearms according to the NRA, it is clear that these weapons are disproportionately used for criminal purposes. Thank you.
Thank you. Go ahead.
My name is Jim Parsons. I'm here today from Bainbridge Island with my wife and family. On October 1, my daughter was murdered in the Las Vegas massacre. According to the police, the FBI, and the coroner's office, my daughter was shot in the back with an AR-15 assault weapon modified with a bump stock at a range of about 4 football fields away as she ran for her life. Most of the shooter's assault rifles had 40 to 100 round magazines. When I visited the site of the massacre, I thought of the power, the velocity, the distance of the bullet. Only an assault rifle modified with a bump stock with high-capacity magazines could fire so rapidly, so many rounds of ammunition without aim, and kill so many within minutes. It took 2 days of heart-wrenching interrogation just to identify my daughter, another 2 days just to see her. The agony will live with our family until we die. Our lives have truly been shattered. My daughter was 31 years old, a graduate of Arizona State, and Carrie had a terrific, well-paid job in downtown Seattle. She was recently engaged to a wonderful young man in September who sits behind us. Carrie will never have the opportunity to be married to the man she loved, never have the opportunity to raise children. And we will never have the opportunity to see our beautiful daughter again because Carrie is not coming home. Carrie's murder, indeed 58 senseless murders, could have been prevented. There is nothing to stop the hail of 100 bullets traveling at 4,000 feet per second, each one with a destructive force to turn a flesh wound into a fatality. And that's just in the first 60 seconds before the shooter reloads. So we support the legislation so that other parents don't have to experience the horrors of having a beloved child, maybe your child, be senselessly slaughtered. Thank you.
Thank you. Go ahead.
Thank you, Madam Chair and members of the Judiciary Committee. My name is Dr. Beth Ebel. I'm a pediatrician at Harborview Medical Center, and I care for the most seriously injured kids in Washington State and the other surrounding states in the Pacific Northwest. I'm also a member of the Washington chapter of the American Academy of Pediatrics, and we represent over 1,000 pediatric providers. We strongly support House Bill 1387. Every week at Harborview, when I'm on call, I take care of kids who've been injured by gun violence. It's stunning. And those are, and I'm going to say the lucky kids who have survived, you know, thanks to world-class trauma care and the path that the bullet took when traveling through the child. But more often, victims who've been shot with an assault weapon do not live long enough to make it to Harborview. In July 2017, a troubled 19-year-old boy brought an assault weapon at Cabela's, read the instruction manual in the car, went to a summer barbecue where he shot and killed 3 teens and seriously wounded a 4th. On October 2nd, 2017, as you heard, one person was able to kill 59 people and injure 500 more. For those of us, such as myself, who see firsthand the impact of an assault weapon on a person's body, their organs, their belly, It's crystal clear that the level of lethality and firepower of these military-style weapons is fearsome and terrible. They were designed to kill people, and they do. They're too easy to purchase. Today in Washington, it's as easy to buy one of these weapons as it is to buy a traditional hunting rifle, and it is simpler to get an assault weapon in our state than it is to get a handgun. And we had the opportunity to change this. It's time to take sensible steps here to reduce gun violence in our state. And one thing I've noticed taking care of kids is the impulsivity of that kid, you know, it's mind-numbing how quickly somebody can make a decision and then act on it with no time to reflect or change their minds. It's going to take courage to support the voices of scientists, doctors, families, and the majority of Washingtonians who support common sense gun laws to keep these dangerous weapons out of the hands of dangerous people. So on behalf of myself, our pediatricians throughout the state, kids, and the families who care for them, I strongly urge you to vote yes on House Bill 1387. Thank you.
Thank you. And Jim and Anne Marie, I swore I would never say to people, I'm so sorry for your loss, because I don't think that's enough. But I feel the need to say that, and I'm certain I'm speaking for the entire committee, and I want to thank you for coming forward and being willing to tell your story when the pain is so deep.
Thank you.
So thank you.
Next panel, Keely Hopkins, Jane Milhens, and Don Amen. That panel will be followed by Raymond Miller, Zachary Elmore, and Beatrice Seward, and then the panel following will be Kelly Burr, Clarendon Gustafson, and William Murphy.
Go ahead, Keely.
Chair Jenkins, members of the committee, my name is Keely Hopkins, State Liaison for the National Rifle Association, here today in opposition to House Bill 1387 and 2422. Semi-automatic firearms are some of the most commonly owned firearms in the United States, and they're used for the exact same reasons as any other firearm: for self-defense, home protection, hunting, and recreational and competitive shooting. They only fire one round when the trigger is pulled, and they're not high-powered compared to other firearms. They use the same ammunition as many other rifles. Standard capacity magazines generally hold more than 10 rounds and are some of the most commonly owned in the United States. Firearms in general, which largely includes these semi-automatic firearms holding 10 or more rounds, are used over 2 million times per year for personal protection, which significantly exceeds the amount of times that semi-automatic rifles are used for violent crime. Treating these firearms differently under state law will have no impact on crime, but it will only limit law-abiding gun owners and their ability to utilize them for self-defense. Following the ban of these firearms and magazines at the federal level, a congressional study found the ban had no effect on crime, in part because these types of firearms are rarely used in violent crime. Police reports and studies have found these so-called assault weapons are used in only 1% to 2% of violent crimes. Here in Washington, rifles of any type are only used in 3% of violent crimes, with semi-automatic firearms being a subset of that percent. Lastly, House Bill 1387 creates a backdoor registry for these firearms by allowing the Department of Licensing to store these records of their sales and transfers. It also creates a waiting period of up to 10 days, which curtails the availability of these firearms for individuals to use for self-defense. Thank you for your time.
Thank you. Hey, Keely, you didn't mention the 2 million times that they're used for protection. You didn't mention where that data came from, so could you just get that to us offline?
I'd be happy to.
Thank you.
Yeah, my name's Jane Milhens. I'm from Pierce County. Several years ago, I opened my front door and was confronted by 2 men in my home. They were uninvited and their intentions were for harm. It's a woman's right to defend herself with firearms for personal protection. It levels the fight between her and her attackers. In my case, it was no fight. I can't defend myself with my fists against 2 men. I'm no match for that. A firearm protects life and gives women a fighting chance to protect their loved ones as well. In a defense situation, limiting a woman to 10 rounds to take a threat out could endanger her. Ask any law enforcement officer how many it takes. There's so many variables, we can't even bring them all up. I live with this nightmare every single day. I have an alarm security system. I leave the lights on. I have cameras. I come before you as a crime survivor. I do not want to be a crime statistic. I want to be able to protect my loved ones and my family. Because of this, I became a certified firearm instructor, and every year I volunteer hundreds of hours training women how to use a firearm for personal protection in sport. Women are the fastest growing group of gun owners in America. The most popular rifle amongst women is the modern sporting rifle, often referred to as an Armalite rifle, AR-15, and incorrectly categorized and insultingly categorized as an assault weapon. In fact, it's just being judged by its appearance. There's no recoil, the stock length can be adjusted, and that's why women use these firearms for sport. We're all law-abiding firearms. We're not the ones terrorizing America and killing sprees, and yet you seek to punish us. On behalf of all the women I've trained and my good friend Bradley, a survivor of the October 1 Vegas concert, a hero who ran back in to save his friends, we ask that you punish criminals and not us law-abiding firearm owners. Thank you.
Thank you. Go ahead, sir.
Thank you for letting me speak. My name is Don Amon. I am one of those Las Vegas survivors. My wife and I were there on October 1st in the VIP section. We were 55 feet away from the stage and 68 feet away from where the officer that unfortunately I had the opportunity to videotape that got shot. The woman that was sitting 3 feet away from my wife was shot in the head and did not make it. During that time, over the course of the last 2.5 to 3 months, I've been asked the same question over and over again. How do I feel about gun laws? There was not a single law that would have protected any of the 21,582 people that attended that festival that weekend, nor will that law ever take place. None of this has anything to do with what happened in Vegas. I ask you to seriously take a look at the emotions and get our emotions in check before we start throwing blanket laws out to not allow people to have the right to defend themselves. I cannot urge you strongly enough. I was there for hours after the effect, after the shooting took place, to help, to aid. I am a fire medic. I am a nationally certified range instructor. I am a safety instructor for the USPSA. I'm a competitive shooter. These laws that you're trying to pass would make me a criminal, and that is not right. I urge you, please, do not let your emotions of what happened in Vegas, what happens, evil people will continue to do evil things. We cannot control that, and we cannot control what they will and cannot do. But you look at Chicago, look at LA, look at these large cities that have these draconian laws in place. Criminals do not obey the law. That is why they're criminals. What happened in Vegas is an atrocity. What happened in Vegas is an anomaly to have something that large take place. And being involved with it was emotionally distressing for my wife and myself. But as a pro-gun person, I ask you, do not make us criminals because of the actions of somebody that I had no control over or had no ability to do. Nobody knew what was going on. Nobody knew where the gunfire was. Please, stop with these laws.
Thank you for your testimony. Thank you to the panel.
Next up is Raymond Miller, Zachary Elmore, Beatrice Seward. On deck will be Kelly Burr, Clarendon Gustafson, and William Murphy. And on hold, Dylan O'Connor, Margaret Gota, and Molly Mattingly. Good afternoon.
Go ahead.
Good afternoon, Madam Chair, committee members. My name is Raymond Miller, and I live in Marysville, Washington, with my wife, Jennifer. And I'm the proud grandfather of 13 wonderful kids. I'm a U.S. Air Force combat veteran. I'm a clinical therapist and a veteran advocate. As someone who has served in the U.S. military, I know the extensive training that members of the armed forces receive. When it comes to operating a gun, I myself learned how to safely handle, store, and shoot a weapon. It is a skill that requires time, practice, and respect for the weapon you are holding. Yet right now, anyone can walk into a store and purchase a deadly assault weapon and dangerous accessories like pump stocks and high-capacity magazines. They don't even have to demonstrate that they know how to safely handle a gun. In fact, it is easier to get an assault weapon in Washington State than it is to get a handgun. These dangerous guns, designed only to kill people, have been used in too many recent shootings, including the Mukilteo High School party shooting. Mukilteo is only one community away from where I live, and I have many friends who live in Mukilteo, and I have saw how that tragic shooting devastated their community. It should not be easy for a teenager in crisis to walk into a store and buy a deadly weapon. Raising the age of purchase to 21 and requiring safety training before the purchase of an assault weapon are common sense safety measures, and we can make sure that we save lives. Thank you so much for your time.
Thank you. Go ahead.
Good afternoon, Chair Jenkins and committee. My name is Zach Elmore. I live in District 36, and I'm here today because my sister survived the worst mass shooting in modern American history. On October 1st, I went from celebrating my birthday at a Seahawks game to getting the most horrifying call of my life. My mom and I flew to Las Vegas the next day, and we were greeted by my brother-in-law, Nick, who still had blood dried on his hands. His blood-soaked shirt was in a bag on the floor of the hospital. Seeing my sister lying motionless from a gunshot wound and surgery to check for organ damage is something I hope nobody ever has to experience. The terror my sister describes kind of brings me to tears. The man standing directly next to my brother-in-law was shot in the head, and one of the 58 who lost their lives. As they ran, my sister was shot in the back. In all the chaos, she sent text messages, potential goodbyes to my mother and to my grandmother, asking my grandma to tell her daughters that she loved them. They managed to get into a truck full of bodies, and the driver got them to the hospital. We know the statistics. You know the numbers at this point. When we talk about high-capacity magazines, assault-style weapons, common sense is decreasing access to these kind of things. You can't, create laws that stop evil, but you can make access to things with which people would perpetrate evil more difficult. And I think that's what's most important when we're discussing laws like this. You guys are our legislators. You know, you have a priority to consider your constituents ahead of the agenda of the gun lobby. Thank you.
Thank you. Go ahead.
My name is Beatrice Seward, and I live in District 29. I'm also a veteran of the United States Army of 25 years. I'm a single mom of 3 adult daughters and an educated, constituent, responsible gun owner. I'm here today to ask you to consider the proposed legislation. The service gave me the opportunity also to learn about assault weapons that most civilians don't have. And based on that knowledge, I strongly recommend and suggest training and the background checks that are proposed before someone can add these dangerous weapons to their arsenal. I've lost my husband, my uncle, my brother, and friends to gun violence. We'd be hard-pressed to find someone who hasn't lost someone to gun violence, which makes me think the numbers that the proposed as far as how many people are injured by assault weapons, how many people are affected by assault weapons might be a little bit skewed in the data that we're receiving lately. The fact that each tragedy caused by assault weapons is the worst in our country's history isn't an accident. It's a decision by someone made to destroy as many lives as possible, and it is possible to prevent the senseless tragedies. Currently, as I've stated, it's easier to get an assault rifle, and I'm hoping that you guys change that. We are always quick to empathize on social media, send prayers and flowers, and there's definitely a time for that. However, now is the time to do something more than that. Thank you.
Thank you. And thank you very much for telling your stories.
Next up, Kelly Burr, Clarendon Gustafson, and William Murphy. That will be followed by the second to last panel on these two bills, Dylan O'Connor, Margaret Gota, and Molly Mattingly. And finally, the last panel on this bill will be Leslie Rieger, Andrew Mesojednik, and Simon McFarland.
Go ahead.
Good afternoon. My name is Kelly Burr. I'm a lifelong Washington resident, currently living in Redmond. I urge the committee strongly to oppose these bills. I've submitted more detailed written testimony than can fit in the 2 minutes I have here. I've also delivered copies of my thoughts to each of your offices earlier this morning. While I do oppose the assault weapons legislation, I'll focus my testimony today on the impacts of magazine capacity restrictions. The argument for magazine capacity restrictions is to reduce the amount of ammunition that a person can reasonably carry or force reloads that would give victims of a hostile shooter a chance to take them down. The intent is to reduce, or shall we say impair, the shooter's ability to do harm. However, the reality is that bearing arms in defense of self or the state means doing harm to your assailants, likely. Our right to bear arms in self-defense does not end with a single attacker, and attacks by multiple assailants are common, especially in a home invasion. Any restriction designed to impair an evil man trying to hurt people equally impairs a woman trying to defend herself against even a small group attacking her in a parking lot or trying to invade her home. Worse still, these bills specifically and unconstitutionally exclude self-defense as legal use of even a grandfathered magazine. It would become illegal to carry them with your concealed pistol license or keep them ready to go for self-defense. The 578,000 legal CPL holders in our state would be required to buy new magazines or new guns to continue to defend themselves and keep their existing magazines unloaded and locked up at home. Worst of all is the undue harm this would cause to people with disabilities or physical challenges, impairing the function of one hand. Reloading a gun with only one functional hand is not practical in any self-defense situation, and these restrictions can go from becoming merely impairing someone's rights to becoming deadly to someone who can't effectively reload due to a disability. Thank you.
Thank you. Go ahead.
Yeah, my name is Clarendon Gustafson, 23rd Legislative District, Tulsa, Washington. I'm here to speak in opposition to bills 2422 and 1387. I oppose these bills strongly, and I oppose the sporting rifle ban and the magazine capacity limits. I'm saddened that we're sitting here debating the banning and or controlling of objects, whether it is magazine capacity limits or certain firearms or accessories, as some type of fix for the loss of life at the hands of another individual. I'd like to look at this from a different perspective. 1 in 6 Americans are using antidepressants or some type of mind-altering drugs being prescribed to the tens of millions. Literally 50 million people are on these chemicals at any given day. Millions of these same people then sit and play extremely violent video games, graphic video games, and have access to unrestricted, unrestricted access to hardcore pornography. The root cause of all these lost lives that we are hearing about in this hearing is a sick and depraved society that has turned into a toxic brew that is producing mass murders and killers at potentially higher rate. Until we take serious steps to heal our society, we will continue to hear these horrible stories of loved ones lost at the hands of others. The banning of objects is a poor attempt to band-aid a problem. America as a whole is turning its back on the church, fundamental truths, real history, good principles, and any sense of normalcy. A progressive movement calls on us to tolerate radical behaviors that are destructive to our way of life. I feel as if my way of life as a rural Washingtonian is under attack by those living in the 206 area code, and they want to export their problems, failed policies, to our healthy communities across the state. Gun control is steeped in racism, as it was used largely in the 1700s and 1800s to disarm slaves in the South and control populations even to this day across the world. I will not be disarmed. I will not be a slave. Thank you.
Thank you. Go ahead.
My name is Bill Murphy from District 1. I'm a mental health professional, licensed independent clinical social worker in Washington, and also a proud member of the NRA, the Second Amendment Foundation, and the Washington Arms Collectors. As a clinical social worker, former legal advocate for domestic violence victims, and a mental health therapist who has treated traumatized crime victims for many years, this bill not only affects my personal safety, but also that of thousands of women, domestic violence victims who must protect themselves from violent perpetrators. This bill makes us all less safe. I became a CPL holder after being assaulted by psychiatric clients, being stalked, and having to thwart a home invasion with nothing but my bare hands. This is to say nothing of the many homeless people where I live, who I know from professional experience working with that population, are armed more often than not. I oppose House Bill 2422 for 3 reasons. First, it impairs and infringes on our rights in the Washington State Constitution, Article 1, Section 24, and the federal Constitution, the Second Amendment. Second, it presents no public interest or safety basis. As a former crime victim advocate and mental health therapist, I can assure you gun violence is a criminal crisis, not a health crisis. Third, this bill establishes the following arbitrary exempt classes in sections 2B, H, I, J, K, and L. Government officer, agent, or employee. Law enforcement officer within scope of duties. And I'll skip a bit here. The bill criminalizes law-abiding citizens simply for magazine possession, and that, of course, can affect employment and housing opportunities. It does recognize the logical need for a law enforcement officer to have more than a 10-round magazine for their protection on and off duty. You must provide the same self-defense rights for us as well. I ask you to follow your oaths to the state and the federal constitutions. These are constitutional rights, not state privileges up for political fiat. Thank you.
Thank you for your testimony.
Next panel, the second to last panel on these 2 bills, Dylan O'Connor, Margaret Gota, and Molly Mattingly. That panel will be followed by the final panel for this legislation, or these 2 bills, Leslie Rieger, Andrew Misojednik, and Simon McFarland.
Thank you. Go ahead.
Hi, thank you. Hi, my name is Molly Mattingly. I'm a student at Seattle University, and I live in the 37th Legislative District. I'm actually from Reno, Nevada. I have a number of friends and family who are indirectly, unfortunately, hurt by the Vegas shooting, as well as friends and family who have been hurt by other shootings, mass shootings around the country. Also, as someone who is in the range of 18 to 21, I definitely, and has friends in that range, support the fact that it should be harder for us to get these types of weapons. Assault weapons are designed to kill people and have been used in too many recent shootings, including Vegas and Sutherland Springs, 2 of the deadliest shootings in U.S. history. Today in our state, it is as easy to buy one of these weapons as it is to buy a traditional hunting rifle. In fact, it is simpler to get an assault weapon in our state than it is to get a handgun. That should not be the case, and we should have the opportunity to change the law. We need more safety measures when it comes to these dangerous weapons that can claim dozens of lives in just a few minutes. You owe it to the citizens of our state to make sure that dangerous weapons do not fall into dangerous hands. Thank you.
Go ahead.
My name is Anna Uman. I'm a constituent of the 46th Legislative District, and I grew up in Skagit Valley. I understand what it's like to be a part of a rural community that does have an investment in firearms as a piece of their culture. But I am supporting all of this legislation because I, first and foremost, understand that it is dangerous to have readily available and readily accessible firearms that can shoot off many rounds all at once, and to have access to that before the age of 21 when your brain is still developing, I think is very, very dangerous to the public and to the owners of those firearms. I also think that this isn't a question of not making firearms accessible. What the question is more implementing consistency in our legislative expectations. If we are willing to sit here today and acknowledge that it is dangerous to have handguns before the age of 21, that there are dangers involved that make it so that we have extra pieces of or barriers to acquiring handguns before the age of 21, I think it would be highly hypocritical for anyone in this room to ignore that while not being able to apply the same standards and dangers to the acquisition of semi-automatic rifles or assault weapons in general.
Thank you. Thank you for your testimony.
Last panel on this legislation on these two bills. Leslie Rieger, Andrew Mesojednik, and Simon McFarland, please come forward. Yeah, and we did have one person who did not show for that panel. I think it was Dylan O'Connor. Dylan O'Connor, if you're here, you have one last chance to come forward.
Go ahead.
Oh, me? I am Leslie Regier, representing myself. My words are directed at those who seek to pass these bills. You further misappropriate the terms assault weapon and large capacity magazine. Some people call them high capacity magazine. That's used as pejoratives against standard guns and standard magazines that are widely possessed peacefully, not used in violence. The difference in paperwork and waiting period between what you call assault weapons and handguns has to do with concealability. That's what it's all about. We have concealable weapons, we have long guns. Don't forget that difference. You use buzzwords like common sense, gun violence. Guns are powerless to act on their own. It requires a person. Why does no one address the criminal? Everyone wants to talk about the guns, not the criminals. This clearly infringes upon my right to own firearms under the Washington State Constitution, which, don't forget, is superior to the RCW and superior to you. If you truly seek to reduce crime in which firearms are used, you must address that which causes the hearts of man to go astray, and I suggest you begin with your own hearts.
Thank you. Go ahead.
Good afternoon. My name is Simon McFarland. I represent myself as a constituent of Bellevue in the 41st District. There's a lot I was going to say that's been said already. I don't want to be redundant. But concerning Resolution 2422, I think what hasn't been mentioned already is that there's sort of a premise of this bill that that high-capacity magazines are rare or expensive somehow. They are not. You can go to Oregon or Idaho or here in Washington right now and get them for like $5 at a gun store. What's more, they are not complex. They're very simple. It's like 2 pieces of plastic and a spring. I know a guy who actually is not a gun owner who printed one with a 3D printer just to see if he could, and he could. I have in my pocket an SD card, a micro SD card smaller than my thumbnail. I could take it to any place in Seattle or on the east side. They could just print it on a 3D printer in a matter of hours. Laws that punish law-abiding gun owners and don't affect criminals is a pretty familiar argument, but I think in this case it's especially relevant because regulating them, somebody who's going to want to do harm with these is going to have the resources to be able to manufacture one, especially now that manufacturing such devices at home is very easy. And particularly, there's actually some language in this bill that bans any conversion kit part or combination of parts from which such a device can be assembled. One has to wonder, especially for a piece of plastic, where the line is drawn as to what constitutes a kit of parts or the parts required to assemble when all you need is a 3D printer and a spring. Thank you.
Thank you. Go ahead.
Hi, my name's Andy Misogynic, and I'm from the 24th District. My family and friends, we regularly use AR-15 style rifles to hunt deer, elk, bear, and coyotes. They don't just come in one caliber, they come in many different calibers. Also, when we were listening to the Deputy AG speak today, he was talking about the ability to buy our firearms online. The part that he didn't allude to that really disappoints me as a representative of the state of Washington is he totally negated the fact that those items have to continue to go through an FFL and continue with a background check. And I really find that statement by him to be very disingenuous and almost untruthful. When we take a look at some of the issues, when as some of the other people have alluded to here, we take a look at the death of Deputy Daniel McCartney here just recently. He was previously a police officer in Hoquiam, in the area where I operate, where I work, and all of that. The people who were involved in his murder had a total of 83 different interactions with the state court system. I've had, in my past, I was a deputy with Whatcom County. Of course, I was just a reserve deputy. During that time period, I worked Friday and Saturday nights, 2 weekends a month. I arrested one guy 7 times in 2 years. There's not a problem with necessarily these pieces of equipment. There's a problem with releasing these people back onto the streets in a catch and release fashion to the point where they escalate their crimes. And if you give somebody enough times at bat, guess what? They're going to hit one out of the park. So please, regulate the criminals. Take care of them. Stop the abuse of law-abiding citizens. Thank you.
Thank you. Thank you for your testimony. Before we end the testimony on this bill, I just want to check, is Dylan O'Connor here? Dylan O'Connor? Great. With that, we'll close the hearings on House Bill 1387 and 2422. We will open up the hearing on House Bill 2293 and hear from Edie Adams.
House Bill 2293 addresses possession of firearms and other weapons on the premises of child care centers. Child care providers are licensed by the Department of Early Learning, and child care licensing statutes currently do not address the issue of firearms or other weapons on center premises. However, they do require that licensing standards include requirements to address safety in child care settings, and the department has adopted safety rules that require licensed child care centers to maintain premises in a safe manner, including protecting children from gunshots by ensuring that no firearms are on the premises. In addition, licensed family daycare providers are required to store guns, ammunition, and other weapons in a locked gun safe or a locked room so that they are inaccessible to children. House Bill 2293 provides that with some exceptions, it's unlawful for a person to possess a firearm and other weapons on child daycare center premises, center-provided transportation, or areas of facilities that are being used exclusively by the center. Prohibited weapons are listed in the bill analysis. They're substantially the same as those that are prohibited from being possessed currently on primary or secondary school grounds or premises. A violation is a gross misdemeanor offense, and a person who is convicted of a violation must have his or her concealed pistol license revoked for a period of 3 years. Child daycare centers must post gun-free zone signs to provide warning of the prohibition on possessing firearms on the premises. The offense does not apply to family daycare providers. However, the bill does require family daycare providers to store any firearm, ammunition, or other weapons in a secure area inaccessible to children while children are on the premises. And if the firearms are stored in a locked room, they must be stored unloaded and with a trigger lock or other disabling feature. And finally, the Department of Children, Youth, and Families may take licensing actions against a licensed child care facility that fails to comply.
Thank you. Questions for staff? Representative Kagi.
Thank you very much, Madam Chair, for hearing this bill. My name is Ruth Kagi. I represent the 32nd District, and I bring this bill to you as part of our state responsibility for keeping children safe in the child care facilities that the state licenses. The biggest response I have heard to this bill is surprise. People are very surprised that we don't currently prohibit firearms in child care facilities. We prohibit them in elementary schools and secondary schools, and young children are exceedingly curious and inquisitive, and nothing is more fascinating than a gun. We don't ever want that temptation to be present for children in our child care settings. So I am going to be brief because I know there are a lot of people here to testify. I'd be happy to answer any of your questions. I really feel like it's our imperative duty to assure that children are safe in the child care settings that we license, and we make a promise to parents that they will be safe to the extent that we can keep them safe.
Thank you. Any questions for Representative Kagi? Thank you, Representative Kagi.
Thank you.
And I forgot to let Representative Kilduff call people up, so hopefully we'll.
Yes, we will have a total of 4 panels on this bill. Panel number 1, Tom Duhamel, Jeannie Shu, and Juliet Scarpa. Panel 2, Katie Bunny, Bill Burris, and Sherry Erickson. And then on hold, panel 3, and we'll get to panel 4, Patrice Griffith and Elisa Daly.
Go ahead. Whoever wants to go first.
Good afternoon. My name is Dr. Tom Duhamel, and I live in the 46th district. I'm a retired clinical psychologist, child clinical psychologist, and formerly the chief psychologist at the Children's Hospital in Seattle. I also have a beautiful 4-year-old granddaughter who attends afternoon daycare. I'm here today to testify in support of House Bill 2293. Places where children go to learn should be safe. Toddlers and preschoolers are curious, and having guns in early learning centers increases the risk of an accidental shooting. Children at this age will play with guns as if they are toys, no matter where they might find them. In their homes or in their classroom, in their mother's purse or in their teacher's purse, in their parents' car or on the school bus. Should you think that toddlers are not often involved in accidental shootings, I refer you to a recent article in a national newspaper titled, "People Are Getting Shot by Toddlers on a Weekly Basis." Some people think that accidental shootings by young children are due to parents or teachers not adequately instructing or warning them about the dangers of guns. What these people seem to forget is that toddlers and preschoolers often do not do what their parents and teachers tell them to do. Their curiosity and their inherent desire to play with interesting objects like guns override their parents' or their teachers' instructions to leave them alone. These and other young children should be able to attend early learning centers that are gun-free. For all of these reasons, I personally and professionally ask that you vote for House Bill 2293. Thank you for your time.
Thank you. Go ahead.
Hello, my name is Jeannie Shu, and I live in the 43rd Legislative District of Washington State. I'm a retired teacher and school psychologist and taught kindergarten the last 9 years of my career. After learning about what happened at Sandy Hook, in addition to my heartache and outrage at the deaths of those little children and their teachers and staff, the safety I had previously felt at my school disappeared. The kindergarteners I taught had already shown they were frightened and anxious during fire and earthquake drills. Now they had to learn to practice lockdown procedures as well. Over the years, my colleagues and I have noticed growing numbers of young children with anxiety issues. Early learning facilities like Washington schools should be places of safety and free of firearms and dangerous weapons. In addition to the horrific possibility of a mass shooting, the lethal presence of a firearm increases the risk of an unintended injury or death. As firearms are the 3rd leading cause of death for children in the United States,
Please reduce the likelihood by passing common sense gun safety legislation like House Bill 2293. Thank you for allowing me to testify at this hearing.
Thank you. Go ahead.
Good afternoon. My name is Juliet Scarpa. I'm a resident of Shoreline, Washington, 32nd District, and a member of Moms Demand Action for Gun Sense in America. I'm here today to express my opinion in favor of House Bill 2293, restricting firearms and dangerous weapons in early learning facilities. I'm a mom to 2 boys, Vincent, 7, and Dominic, almost 5, and we are currently finishing what will be our 6th and last year in our licensed center-based childcare. The teachers and staff have become an important extension of our family over these most formative years. They've cared for and nurtured both of my boys, teaching them how to write their names, use a cup, clean up toys if we're lucky, use soft hands and kind words with our friends. They work hard to make sure that all of this goes on in a safe environment. It has never crossed my mind that I would have to worry about guns being brought into this safe place. Current law recognizes this. Children and firearms don't mix. The elementary school that Vincent attends is guided by state law generally prohibiting weapons of any kind in school. We assume for our youngest that they are protected at the same level as our older children. House Bill 2293 would extend this same level of protection and safety to our youngest Washington residents, as well as the staff and caregivers that we entrust to teach and nurture our children in our absence. I urge you to vote in favor for this common sense gun legislation on behalf of both of my sons, their friends and teachers, and the families and caregivers in Washington State. Thank you.
Thank you.
Next panel, Katie Bunny, Bill Burris, and Sherry Erickson. They will be followed by Patrice Griffith and Alyssa Daly. And then the final panel on 2293 will be Zachary Roback and Jason Dupeau.
Thank you. Go ahead. Go ahead.
Oh, my name is Sherry Erickson, and I'm a member of the 28th Legislative District. I'm a mom and a grandma and a responsible firearm owner. HB 2293 does not stop gun violence. What it does is make every daycare, childcare provider, and early learning facility a target. Anyone mentally ill, anyone with criminal intent is not interested in obeying the law. Criminals are interested in easy targets. Having to post a sign declaring a facility as a gun-free zone is advertising that they are unarmed and vulnerable. Donors to the backers of this bill protect their kids with armed guards. Why can't I protect my family the same way? A parent or a grandparent who is a law-abiding concealed carry gun owner shouldn't be made a criminal every time they pick up their kids or grandkids. If there is a lethal threat, it needs to be stopped immediately. Law-abiding parents and providers with concealed carry permits can level the fight in a lethal threat situation, but only if their firearms are not locked up. I thank you in advance for voting no on this bill and protecting a woman's right to protect herself and her family. Thank you.
Thank you. Go ahead.
Chair Jenkins, members of the committee, thank you for the opportunity to speak on House Bill 2293. I am William Burris, retired detective from Pierce County Sheriff's Department, here representing Gun Owners Action League. Everyone wants to protect children. This legislation is written amidst language which appears elsewhere in the Revised Code of Washington. Specifically, does not apply to any person in possession of a pistol who has been issued a license under RCW 941070 or is exempt from the licensing requirement by RCW 941060 while picking up or dropping off a student. Child may be substituted for the word student. This wording should be included because possession of a concealed pistol license does not cause nefarious intent or action. Experience demonstrates that it is often domestic disputes which lead to violence in the workplace. When a protection order is obtained by anyone working in an early learning facility, that person should either remain off the premises or alternatively, all parents and guardians concerned should be notified of the situation until the protection order has been resolved. The duty to protect children from such risk just makes common sense. Thank you.
Thank you. Go ahead.
Chair Jenkins and committee members, I apologize that Katie Bunny could not be here and she asked me to testify in her place. My name is Phil Shaven. I represent the Washington Arms Collectors, and I ask you to oppose House Bill 2293. I do recognize that it's well-intentioned, but a well-intentioned bill that creates more risk to children than it actually removes. I'd like to focus on 3 serious flaws in 2293. First, the bill requires the posting of a sign creating yet another gun-free zone, and this is a serious threat. It actually creates a magnet for the emotionally disturbed. Have we learned nothing from San Bernardino, California, and many other places? All gun-free zones. In San Bernardino, there was a 3-minute police response, and yet 14 people were killed. The gun-free zone is not the solution. The second point I would like to make is that requiring our nearly 600,000 concealed pistol license holders who are just ordinary people picking up and dropping off their children at a daycare, requiring these people who have been fingerprinted and background are most responsible citizens, and 2293 singles them out and says, yes, we've licensed you, we've fingerprinted you, we've backgrounded you, but that doesn't count. And finally, the danger to the people and the children at the daycare center is created by the bill because it requires the unloading of firearms for secure storage at the facility. That's a mistake.
Any questions for the panel? Thank you to the panel.
Next panel, Patrice Griffith and Alyssa Daly, please come forward while they're making their way on deck. And the last panel on this bill, Zachary Robeck and Jason Dupeau.
Go ahead, ma'am.
Thank you. My name is Patrice Griffith. I live in the 36th Legislative District, and I'm here on behalf of the League of Women Voters of Washington. We completely support this bill. It could not be a more common sense bill. Kids' sense of curiosity overrides any instructions from parents or teachers, and we've heard far too many stories of toddlers at Walmart rummaging through their mother's purses and finding a weapon. The same thing can happen with a momentary lapse of adult attention in a child care facility. And I appreciate that this bill affects things like stun guns as well as pistols and other weapons. And the requirement for family daycares to lock up and store weapons is what any responsible gun owner should be doing. Thank you. Please support this.
Thank you. Go ahead.
Hi, my name is Alyssa Daly. I'm a volunteer with Moms Demand Action, and I have 2 little boys who are 9 and 3 years old. I live in the 21st Legislative District. I'm here in support of House Bill 2293, a common sense gun measure that will help keep my children safe when they are not in my care. My oldest son is in 4th grade in Linwood. There's a sign outside of his school stating that guns are not permitted. Visitors during the day, as of this week, have to be buzzed in through the doors to enter the building. They practice active shooter drills in his classroom. Although it is devastating that this is all necessary, I'm so grateful that our school takes every possible measure to safeguard my child. In the summers, however, we enroll him in childcare. As of now, the moment school lets out and he enters his summer program, the precautions in place for his safety melt away. There is no such sign outside of that building, even though the occupants inside it are just as vulnerable as those in his school. If we deem these measures necessary for schools, why should another building full of children and designed for their use be treated differently? The fact that an evil person might still break this prohibition does not absolve the state from doing everything in its power to protect my child. Thank you.
Thank you very much for your testimony.
Last panel, Zachary Roback and Jason Dupont. Good afternoon.
My name is Jason Dupay. I came here to oppose this legislation. Accidental shootings by children are at the lowest point in this country that they have ever been measured. They are far less common than threats to schools from outside. The best way we can defend our children is to allow people licensed and equipped to protect them on campuses. Concealed carriers are less likely to commit violent crimes than police, and they are the fastest possible response to a danger to a child. The premises of the legislation and those who support it seem ridiculous to me. That there would be someone licensed to carry a concealed weapon just standing there allowing a child to rifle through his holster and see what he can find. It's unrealistic. A person who has a concealed weapon is going to be constantly defending that weapon. You know, they're going to keep children away from it. It's not going to become a threat. And the statistics show that it doesn't become a threat, hardly ever.
Mr. Dupay, you made a number of assertions about what the data shows on a number of things in your testimony. Could you please send email the committee the research base that you're getting that from?
Yeah, I'd be happy to.
Thank you. Thank you. Go ahead.
Afternoon. Trying to prevent kids from playing with a firearm.
Can you please introduce yourself?
Sorry. My name is Zachary Roback. I'm from Port Orchard. I'm just here trying to hear everyone's side of the story. Trying to prevent kids from, accidental shootings. I feel like it's more of a education issue instead of just keep them in the dark, because kids are always going to be curious. So if we just bring the firearm to light and teach them safety, and not play with it, but get it out of their system and understand how it works, then they'll be less likely to be curious when the parents aren't home and rummage through everything. I just feel like education is a route we should be going instead of just more legislation and prevention. Thank you.
Thank you. And that was our last panel on this bill, so we will close the hearing on House Bill 2293, open up the hearing on House Bill 2519.
House Bill 2519 addresses requirements related to concealed pistol licenses. For a little background, there are a number of protection orders, no contact orders, and restraining orders under which a court may require a person who's subject to the order to surrender the person's firearms or any concealed pistol license. Under certain circumstances, surrender under one of these orders can be to a law enforcement agency. In 2015, the legislature created a process related to the return of a private firearm that's in the custody of law enforcement agency. And under this statute, a law enforcement agency may not return a private firearm to a person until the agency determines that the person is eligible to possess a firearm and at least 24 hours have elapsed from the time the firearm was obtained. House Bill 2519 amends this statute to provide that a law enforcement agency may not return a concealed pistol license that has been surrendered to or impounded by the agency to the licensee until the agency has determined that the person is still eligible to possess firearms and meets other eligibility requirements. House Bill 2519 also adds extreme risk protection orders and stalking and sexual assault protection orders to a current statute, making a person ineligible to possess or ineligible for a concealed pistol license if the person is subject to a court injunction regarding firearms under specifically listed protection orders and no contact and restraining orders. Be happy to answer any questions.
Questions for staff? Thank you. Representative Lovick sent me a note. He is under the weather and is not here and able to testify on his bill. He did want the committee to know that he remains very supportive of his bill and urges people to vote for it. But with that, we'll open up the public testimony.
Yes, thank you, Madam Chair. We'll have two panels on this bill. The first panel, Doug Levy, Greg Lineberry, and Frederick Webster. They will be followed by Trevor Quinn, Skylar Barbeau, and Zachary Roback.
Go ahead, Doug.
Thank you, Madam Chair, committee members. I'm Doug Levy. I'm here this afternoon before you on behalf of the City of Everett and bringing you a bill that I think is designed through Representative Lubbock's prime sponsorship to just bring consistency to the laws that the legislature has previously passed and directed with respect to what happens with the surrender and return of firearms versus the surrender and return of concealed pistol licenses. We think, Madam Chair, this may be one of those unintended consequences where there wasn't consistency to those two parts of the law. The bill before you today is meant to do that, and I'm going to turn it over to Mr. Lineberry to kind of go through the circumstances that led Everett Police Department to discover this and ask for the bill you see before you today. Thank you.
Go ahead.
Good afternoon, Captain Greg Lineberry, Everett Police Department. One of my job responsibilities is oversight of our property and evidence functions. Under state law, there are certain court orders, such as the Domestic Violence Protection Order and Extreme Risk Protection Orders, that require the subject of the order to surrender firearms and any concealed pistol license. When the order expires or is rescinded, state law requires us to return firearms without unreasonable delay. Typically, that delay could be up to 4 days while we conduct required background checks and notify any involved victim of the upcoming release if that notification was previously requested. However, we have no authority to delay release of the CPL, and with the CPL, an individual could lawfully purchase and immediately gain possession of a firearm well before we have had made notification to a victim that has previously requested it. We had that very situation occur in Everett last summer, leading us to request this legislation. We believe the current law fails to satisfy your legislative intent as it fails to protect the victims and petitioners of these orders as you intended. For that reason, we strongly support House Bill 2519, which will allow us to delay CPL release for background checks and victim notifications the same as we do for firearms. We view this as a technical fix to make our procedure for release of concealed pistol licenses consistent with the release of firearms and consistent with your legislative intent. Thank you.
Questions? Thank you.
Next panel, Trevor Quinn, Skylar Barbeau, and Zachary Roback. Mr. Frederick Webster was just called. I don't think we've heard from him. If he's still here, you can still make your way forward to testify in this legislation.
Okay, all right, great. Go ahead.
Good afternoon. I'm Skylar Barbeau from Snohomish County. First, I want to say I served in the Marine Corps 4 years and 4 years in the National Guard. I've signed up to oppose and to testify on all the bills today. This is the only one I've gotten to speak on, so I kind of want to speak generally on all the bills. I oppose them.
You need to speak to this bill. This is a hearing on House Bill 2519, so please keep your comments limited to 2519.
All right. I see room for abuse. Kind of changes how I have to keep it to this bill.
We can come back to you. Why don't we come back, see if you've got some final thoughts, and we'll hear from your colleague. Go ahead.
All right. Good evening. My name is Trevor Quinn from Port Orchard, Washington. I stand opposed to House Bill 2519 due to the fact, as he mentioned, that there is room for abuse in this. There's been kind of an atmosphere across the country lately of false accusations of rape or sexual molestation. And there's already been some laws passed throughout the country, and I believe it's in Texas and in Washington, where if someone accuses something of domestic abuse, then their rights to firearms are revoked. Second Amendment is pretty clear on that. It shall not be infringed. If there's the issue of victimhood and people being assaulted, if you're concerned about them hurting another person, they shouldn't have access to that person. They should be in jail if you think they're going to hurt someone. Taking a gun away from them for 24 hours I don't really see how that does anything other than chip away at the Second Amendment. So I believe that, we should just be better off leaving it be. If someone is a threat, they're a threat, and they get handled by the police. If they're still a threat, they don't come back. That's about all.
Thank you. Sir, do you have any final comments?
I guess I can expand a little bit on what Mr. Quinn's saying. The room for abuse, I've kind of observed over the last few years that it has become more common that as a means of getting revenge on a partner or someone else, they can call in a false report on domestic violence or sexual harassment, stalking, or whatever. And I don't think it's going to be right that people who have their rights of carrying firearms can have those rights taken away on something that's false. And I've had some experience in the legal system, and I know how much of a pain it is to go through the legal system to get rights restored and to fight false accusations and charges. So that's about all I got to say on this.
Thank you. And Mr. Roback, are you in the room, and do you wish to testify? Okay, he does not. Okay, but he's indicating he's. Thank you. With that, we will close the hearing on House Bill 2519. I wanted to thank everyone who was here today and everyone signed in for very respectful testimony. We may disagree on these issues even vehemently at times, but you as members of the public have actually illustrated to both the public and the legislature that while we disagree, we can have reasonable conversation that's not incredibly confrontational and harmful, and that's very important for the legislature to see and for other members of the public to see. So I want to thank everyone for that. I also want to note that anyone who did wish to testify who we weren't able to fit in today, you may submit written testimony to staff or email it to staff at any time, so please feel free to do that. And with that, the Judiciary Committee is adjourned.